The Chicago Bar Association was created back in 1874 as just a general resource to help attorneys network with each other and be successful in their practices. The CBA chose to set up the insurance subsidiary because a lot of the members were asking questions about what types of insurance they should tap into. Who's the best resource for legal malpractice insurance, life insurance, health insurance, et cetera, et cetera. And rather than sending those elsewhere, we figured we'd be a better resource if we just kept it all in-house and they had a familiar face to work with on a regular basis. And we think that it's very important to get the word out and let our members know that we're around to help as a resource. On top of that, we can work with any law firm or any attorney in the United States. When a law firm comes to us for a second opinion on their legal malpractice insurance policy, we're usually able to find them a lower price for the same coverage or better coverage, or in some instances, actually both. We can find a lower price for better coverage, which is obviously the end goal. Insurance is something that not a lot of people know the ins and outs of it, and maybe a smaller firm or a solo attorney needs that consultant to really keep them in line or to provide information to take it off of their plate. They have enough going on dealing with clients, collecting bills, doing everything that makes them successful in their profession. What I'm here to do is to be a resource and really to just provide assistance in something that they are not inherently an expert in.
When you need a lawyer, how do you find the right one? Contact the Chicago Bar Association.
Whether you've been injured or need a will prepared, whether you're buying a home or starting a business, having the right lawyer is essential. The Chicago Bar Association have lawyers who practice in most areas of law and speak a variety of languages.
Don't leave it to chance. Get a referral to a screened, experienced lawyer. Visit chicagobar.org or call 312-554-2001. The Chicago Bar Association. Se habla español.
I'm Mike Al-Karaki. I'm a member of the Chicago Bar Association and a partner at Leahy & Hosty, LLC, a plaintiff's personal injury and medical malpractice law firm. On today's show, we're going to explore the forthcoming Illinois Workplace Transparency Act, which seeks to promote employees' rights, particularly as they relate to sexual harassment. We're lucky to have two great guests with us. Dan Raspatello is Assistant General Counsel at ABM Industries, which provides facility services across the country and internationally. Dan has practiced in the area of management-side labor employment for virtually his entire career. And Bridget Dignan is an attorney, a partner at Lathrow & Dignan, another personal injury medical malpractice firm, and has been instrumental in the drafting and passage of the Workplace Transparency Act, which is expected to be signed into law by the governor very soon. She wrote the act, so we're very happy to have you both here, and they both have special insight into the issues we're going to be addressing today, and I'd like them both to take an opportunity to give you more background about themselves. Bridget, why don't you go first?
Thank you, Mike. My name is Bridget Dignan. I'm a plaintiff's attorney practicing in the field of medical malpractice and construction negligence. I entered in this discussion for the Workplace Transparency Act and was one of the chief authors of the act through my participation as a co-chair in the Legislative Committee for the Women's Bar Association of Illinois. I've also worked with the Illinois Trial Lawyers Association's Women Caucus, where I lobbied for this bill, and I've been involved in the Illinois State Bar Association Women in the Law Committee, where we also have discussed the bill.
Yeah, so I've been, as Mike said, practicing labor and employment law in-house for virtually my entire career. I'm not obviously nearly as impressive as my colleague next to me here. But, I'm excited through this process and discussion, to learn how a company or any company, when it comes to implementing rules like this, and how to update your training policies and all those things to make sure you come into compliance.
So let's start with a little bit of background in terms of, obviously there's a problem that this act seeks to address, improve. There are other remedies, other statutory, there are other statutes out there that address some of this stuff. There are obviously the federal claims that can be made. What precise purpose or series of purposes does this act seek to promote?
Well, this came about in my capacity as the co-chair for the Women's Bar Association Legislative Committee. I was asked to testify before the task force in Illinois House. They have a sexual harassment task force that they assembled. And I testified there. It was kind of in the heart of the Me Too moment when the Harvey Weinstein issue started coming to light. And what I was asked about confidentiality agreements and forced arbitration in that context. And there was a member of the assembly who said, I think it's preposterous that women will sign away their rights to disclose and to litigate sexual harassment claims. And so I explained to the panel that it wasn't as though once it happened, they were waiving their rights to litigate and to disclose these the conduct, but that in the beginning, as a precondition to employment, they were forced to sign these agreements in order to get their jobs. And these agreements stated that all employment issues, which included unlawful discrimination, which included sexual harassment, and anything else that fell under that umbrella, were to be secret. Basically, they couldn't disclose any of that. It had to remain confidential, and then any such claims had to be arbitrated. And these arbitration processes, although they can be agreed to between the parties if there is equal bargaining power, the problem is that for the most part, they're pro-employer arbitration processes, and where these individuals could not bring their claims to light. So not only the issue was that women could never address this in the public, with regards to litigation and et cetera, but that those women that would go to work at these companies didn't know about the past conduct and didn't have any idea about what they were getting into. So that was kind of a two-pronged approach.
Sure, and prior to, I suppose even now until this becomes law, those pre-employment contracts, which included, sounds like, non-disclosure or confidentiality, as well as the other prong, the forced arbitration or compulsory arbitration. Have these generally held up as not void against public policy prior to what is sought to be achieved by this act?
Correct. NDAs and arbitration agreements, if signed by both parties, have not, because, and the reason why is that not necessarily because they don't go to court, or not necessarily because the courts hold them up, but because if you lose before court, you're subject to attorney's fees and costs. And so when you're talking about just an employee who is now not working because either she left her employment because she was sexually harassed or unlawfully discriminated against, now may be on the hook for attorney's fees and costs if she loses in court. Sure. So most of the time they're not even challenged.
Sure, that's a major disincentive against an individual who can't afford to bear that kind of risk most of the time.
Correct.
Right. And Dan, in your experience, I know that obviously you're here in Chicago, in Illinois, but your client has offices really across the country and beyond. What is, just in very general terms, without digging into the specifics of this Workplace Transparency Act, what is your experience or knowledge base for these types of agreements? I'm not asking about your company specifically, but is it something that you're familiar with and have come across with some frequency?
Yeah, I think that you have to take a step back whenever one of these new laws pass, which occurs in all 50 states all the time, and really think about what's important to you. What are you trying to get from these agreements? And I think a lot of the time it's protecting your proprietary information to make sure that your competitors, when an employee leaves, doesn't take something they learned just from your company and use it elsewhere, right? Now, I think that what people are going to be doing with the passing of this act is looking at those clauses and making sure that they're not overly broad and they're not limiting or giving the intent or perception of limiting employees from engaging in what we want to call whistleblower activity or bringing forward claims to the IDHR or EEOC or the respective state agency in other states. So a lot of times these can be good things for companies. You take a look, make sure that you're protecting what's important, and maybe you can kind of catch something else in there that was also in your agreement that, hey, we don't like this. This might be a little bit too broad in another section that you weren't even considering. So, I think that from an employment standpoint, or from the employer side, you get some good can come from this as well.
Sure, and I think before we dig into the act itself a little bit further, I think it's important to, I think certainly thanks to the Me Too movement and just the people generally, I think have a very basic understanding at least about what sexual harassment is. Although there are certainly nuances to it, and the more the conversation develops, the more there are sort of peripheral issues people might not have considered, which are actually a lot more important than maybe we had recognized, up until recent events. But without doing a full sort of presentation on what sexual harassment is, can you give us some examples or some guidance on things that are maybe not so obvious, that are becoming more obvious as this knowledge develops further?
Well, I would just say that you're right about that, that before this movement, before all of this started to become a topic that you hear every day in the news, sexual harassment was kind of this broad, vague term. What does it mean? And what does it mean to the person who's sexually harassing? And what does it mean to the person who's being harassed, right? And that was kind of, I guess, the nuance in that people believed that, well, maybe what I'm doing is correct and that person is too sensitive, and maybe that person who's sensitive is not sensitive, but being reasonable. And so the law has always been what is reasonable, and people have a hard time determining what that is, especially when you're talking about the workplace. And that was one of the main reasons of why we wanted to draft this bill. That we were told by the task force, hey, women lawyers, get out there and start doing something about this. And so we did. And I think it's important to kind of, and that's why we did the training piece in the Illinois Department of Human Rights. And so they became involved in the negotiation portion of the bill. And what we did is we looked at other states and what it is that they do in terms of create a model program that they can put on their website that's going to train employers, small employers and large employers as well. And part of it was going to be that you would use this model to train your employees, or you can develop a model that's better than what the department has developed. And it'll provide examples of what sexual harassment is, the responsibilities of the employer in that regard, a summary of the laws, state and federal, that are in place. Because really, we don't know all of this. And I know you don't want to get into what all of this is, but now it's going to be at the forefront when you start a job, because on an annual basis now, employers and employees and everyone involved is going to have to go through this training program so that everyone can be on the same page. And that's kind of the point, so that no one can pass the buck. Everybody understands what their obligations are, everyone understands what their role is, and everyone understands, for the most part, what sexual harassment is in the workplace.
Sure. Dan, anything to add?
Yeah, I think to your point about kind of Illinois seeing what other states did in implementing it and building from there. When you're at a big employer, there's a strong chance you already have a lot of this stuff in place, right? And you're now just taking it and moving it to another state, right? It'll be interesting to see how I think employers that are more centralized in just Illinois, your primary employee base is in Illinois, that aren't in other jurisdictions that are more progressive with their laws, such as California and New York. I think it'll be interesting to see how they go about implementing, because they're going to be starting from scratch probably in a lot of incidents. Maybe they have training at a supervisor level or something like that, or hopefully at least. And now they're going to have to try to figure out how to, bring it on down to every single person in the organization.
Sure. So I understand that this act is part of the package of legislation in which this act is situated. There are amendments to other somewhat related existing laws, is that right? Including the Human Rights Act, the Victims Economic Security and Safety Act, and others. Is that right?
Correct. Yes.
Can you tell us? Now we're a little bit outside the Workplace Transparency Act, talking about sort of a larger initiative that is in this package of legislation, but can you tell us a little bit about the background of the laws that are amended by this package?
Yes.
and how the amendments are expected to operate.
Okay, so the Workplace Transparency Act itself is a new act. So it just basically prohibits NDAs in most situations, and which is the non-disclosure agreements that we were talking about.
As a precondition to employment.
As a precondition for employment and as a unilateral condition. So employees can still come in and they can negotiate these under certain circumstances. And like to what you said with regards to the propriety secrets and things like that, that your company wants to keep secret, and that is not against public policy. I mean, this is just to address a very small, area of conduct that's not
Right. It's narrowly tailored. To
narrowly
sexual harassment.
tailored. Yeah,
Right.
that's the word I'm looking for. So that's against public policy, and then to strike that arbitration issue. The amendments are really to address now. Other parties came to the table once once we filed the bill. Other parties came to the table and decided this is a good act where we can start to fill some of the gaps that are missing in this regard.
I'm going to stop you right there just because of a timing issue, and you're doing great, and we're going to get into all that when we come back for part 2 of this, and we're going to wind up this first section right now and be back to talk for Bridget to pick up right where she left off. Thanks very much.
The Chicago Bar Association was created back in 1874 as just a general resource to help attorneys network with each other and be successful in their practices. The CBA chose to set up the insurance subsidiary because a lot of the members were asking questions about what types of insurance they should tap into. Who's the best resource for legal malpractice insurance, life insurance, health insurance, et cetera, et cetera. And rather than sending those elsewhere, we figured we'd be a better resource if we just kept it all in-house and they had a familiar face to work with on a regular basis. And we think that it's very important to get the word out and let our members know that we're around to help as a resource. On top of that, we can work with any law firm or any attorney in the United States. When a law firm comes to us for a second opinion on their legal malpractice insurance policy, we're usually able to find them a lower price for the same coverage or better coverage, or in some instances, actually both. We can find a lower price for better coverage, which is obviously the end goal. Insurance is something that not a lot of people know the ins and outs of it, and maybe a smaller firm or a solo attorney needs that consultant to really keep them in line or to provide information to take it off of their plate. They have enough going on dealing with clients, collecting bills, doing everything that makes them successful in their profession. What I'm here to do is to be a resource and really to just provide assistance in something that they are not inherently an expert in.
Welcome back for part 2 of this episode of You and the Law. We're here with Bridget Dignan and Dan Raspatello, and we are discussing the Workplace Transparency Act, which is expected to be signed into law by the governor very soon. And when we left off, Bridget, Ms. Dignan, was talking about some existing laws that the legislative package, which includes the Workplace Transparency Act, is modifying, amending, updating, and are relevant to fully understand the aims of this, the policy objectives of this act. So, Bridget, if you could pick up where you left off. I know you were talking about the Human Rights Act, the Victims' Economic Security and Safety Act, and the Illinois Government Ethics Act.
With respect to the Victims' Economic Security and Safety Act, it now only includes sexual violence and domestic violence, and by including gender violence, now it's for actual or perceived gender to also include the transgender population. With regards to the Illinois Department of Human Rights Act, the amendments are made to really just streamline, again, the reporting process. Now, adverse rulings and adverse judgments against employers are to be reported. This is going to help because in the beginning, when we started to research this and to find out really how much of a problem this is here in Illinois, we were unable to get any accurate data on that because the reporting is just not there.
Sure.
And whether it be because employees are not reporting it or employers, We only know what has been filed with the department and the EEOC. So this is going to help with making sure that the data is correct and up to date.
Great. Anything to add with respect to any of these three existing statutes?
Yeah, well, I
I
think
know you have more of a national focus, and Bridget's really deep into this specifically, but if you have any sort of overarching thoughts that may be relevant, feel free to share them.
Yeah, I think I'd imagine that the IDHR is going to kind of give some more clarity on what exactly needs to be reported outside of just jury awards and stuff like that. I'd imagine the intent of this is not chill settlement. I know there's some reference to settlements in there, but I'd imagine when it comes to you progress past the EEOC IDHR stage into federal court or state court. I'd imagine the intent of this act is not to chill settlements because people are afraid of reporting, but to more focus on jury awards and that. But is that correct? Or
It is correct. Adverse rulings, really,
Yeah.
Because we didn't want to prevent parties from settling, because that's the goal in most of these cases. And in fact, that was a source of confusion in the beginning of the negotiation of this bill, that we were trying to eliminate confidential settlements, and that really wasn't the case, because a lot of people who are involved in these sexual harassment cases or discrimination cases, they want their identity to remain confidential. And so it gives both parties the option to do that. But under certain circumstances, it can't be one-sided anymore. And really the purpose of all of this is to equalize the bargaining power between the parties, employer and employee. And then to address your question regarding the Illinois Government and Ethics Act, it's in that case, in the government case, state-related municipalities, as well as in the private workforce, there's always an issue as to who do I bring this issue to, who do I complain to, and how is this addressed? So it really streamlines that process as to whom you address sexual harassment complaints and how that's processed.
Sure, Dan, in your experience, have you found that having sort of a protocol or a standardized practice for the reporting of these sorts of complaints is absolutely necessary, because there's so much confusion and emotional issues and financial issues surrounding it, that there needs to be a real clear path in order to get these issues resolved properly?
you're talking about the reporting of claims?
Yes.
Like outside of your entity?
More specific. I should be more specific. Not the reporting of actual legal claims, but the internal reporting of employee grievances related to harassment issues.
It is important for a lot of reasons. Most importantly, you just want employees to feel safe at work, and that's important. That's how you retain employees. That's how you keep good employees. That's obviously not a legal opinion. That's just probably good operations, good human resources. What a lot of it you'll see, like at bigger companies, is you'll have an anonymous hotline, right, where you can pick up a number, call, and you don't have to give your name, and it gives employees the comfort to report their boss hopefully without fear of retaliation. Obviously, you can't put yourself in any employee's shoes, so you don't know if that is, but that's the purpose of them, right? Is to give that. So, and then I think if a lot of companies will then have internal resources to monitor the effectiveness of that, how much are coming in, and you want to be and then making sure that you're doing coaching or training or investigations of the supervisor that the allegations are against. You want to make sure that you're monitoring that stuff. You don't want bad supervisors. And by keeping records and tracking all that stuff, and by keeping your own data, you're making the work experience better, and you're also making sure that you're not keeping supervisors employed that are, for lack of a better word, repeat offenders.
Sure. And I think it would be, the reality is that most people, I don't know about most people, but there are plenty of people certainly who don't have the benefit of a large corporate structure with standardized protocol for dealing with these things. And so many people are probably in small, employment settings where the interpersonal relationships are so fragile and there's so much of a disparity in terms of power, where they really may feel like they don't have any options. Is that something that this this act seeks to remedy, and does it apply to employers of any specific size?
It applies to all employers, and the purpose behind it is that, for what you just said, is that, sexual harassment, unlawful discrimination is bad for business, right? So this isn't just about creating legal remedies. This is about creating a safe workplace, like Dan had mentioned, and a workplace where when you start working, freedom from sexual harassment, freedom from unlawful discrimination is now on the mind, right? Because you have your annual training, you have other things that are put into place that now you cannot do. That's going to keep that in the dark. It's now brought to light. That's the point of the name of the act, the Transparency Act, and we hope that, going forward, it's going to prevent not only not having an avenue in which to report it, in which to go forward with it, in which to resolve your claim, but that you're able to feel comfortable in the workplace.
Great. So I want to switch gears a little bit and go back to, you gave us a little bit of an overview of your role in the legislative process, and from drafting and advocating in support of the bill to the hearings and testimony. It'd be, I think, we don't have enough time to get into all that, but if you can share some, whatever you think are some noteworthy highlights from that process, whether it was, anything ranging from, support, people's enthusiasm for it, to, I imagine there are also some hurdles that you had to overcome to get it where it is now, and if you could share with us just some of that experience, whatever you think might be relevant or interesting.
Well, it started with this testimony before the task force, and when I was told by a leader there who I know from, I had worked with the Illinois State Legislature as assistant counsel to Speaker Madigan in 2007, and so I was told, you women lawyers aren't doing enough to address this, and I left and I thought, she's absolutely right, we're not doing anything, and so that was when I went back home and kind of put pen to paper and came up with this. Finding a sponsor wasn't difficult in the Me Too era. I mean, this was not, and a sponsor, I mean a legislator that would carry the bill. Once it started to get going, there were other parties that wanted to jump in with regards to legislation that they thought was appropriate and that fit that was germane to what we were going for. And that's where you see the changes that we talked about earlier, the amendments to the other acts. What I thought was the best part of this is that Melinda Bush, she's the senator that carried the bill. She's a very moderate senator and someone who wanted everybody at the table. So the Chamber of Commerce was really a big part of this bill. And I think that's important because, like I'd mentioned before, I don't think any employer in Illinois wants to have an environment where an employee feels unsafe, where sexual harassment is going on, where unlawful discrimination is permitted. I think that the chamber had an interest in being involved in this, and they did. They were very involved in it, and at the end, this was an agreed bill. There wasn't any opponents to the bill.
Great, that's great to hear. I know I've mentioned that the bill is expected to be signed into law sometime soon. With the last minute or so we have left, can you give us a quick status on what to expect next?
It's on the governor's desk.
Okay, any day now?
Any day now.
Any day now. Okay, Bridget, Dan, thanks very much for appearing today. We appreciate your insight and all the work you've done in this regard. And of course, to our viewers out there, we thank you for tuning into this episode of You and the Law.